So, friends, Donald Trump's DOJ lawyers are all but daring the federal judge who's presiding over the Abrego Garcia case, the unlawful, unconstitutional deportation of Mr. Garcia. The DOJ lawyers are all but daring the judge to hold them in contempt. And it sure looks like things are headed in that direction. Let's start with the new reporting, and then let's turn to the new court ruling by Judge Xinis, the judge who's presiding over the Garcia case. First, this from the New York Times. Headline: Judge accuses government, meaning the Trump administration and his DOJ lawyers. Judge accuses government of willful and bad faith stonewalling in deportation case. And that article begins: a federal judge in Maryland blasted the Trump administration on Tuesday for flouting her instructions to answer questions about what steps it had taken and planned to take in seeking the release of a Maryland man who was wrongly deported to El Salvador last month. The sharp rebuke by the judge, Paula Xinis, contained in an 8-page order, suggested she had lost her patience with the Justice Department's pattern of stonewalling her in the case involving the deported man Kilmar Armando Abrego Garcia. In her order, Judge Xinis accused the department, the DOJ lawyers, of a willful and bad faith refusal to comply with discovery obligations. She also dismissed as specious its, the DOJ's, attempts to evade providing information about how Mr. Abrego Garcia ended up in a Salvadoran prison by claiming that it amounted to privileged state secrets. Now, friends, let's jump right into the judge's new order. And when we're done reviewing some of these dramatic findings she makes, we're going to talk about the real-world consequences to the DOJ lawyers who have been called out for their falsehoods and their willful bad faith. In the case of Kilmar Armando Abrego Garcia et al. And others, plaintiffs versus Kristi Noem, Secretary, United States Department of Homeland Security, and others, defendants, order. Pursuant to this court's letter order regarding the filing of discovery materials, plaintiffs have notified the court of seemingly intractable discovery disputes that require immediate attention to remain on the expedited discovery schedule. To facilitate the just and expeditious production of discovery, the court rules on defendants, meaning the Trump administration and the DOJ, defendants' stated objections included within their answers to interrogatories and responses to requests for production of documents. Number 1, false premise objections. Friends, can I just set this one up? You have undoubtedly heard, probably many times over, that the judge previously ordered the Trump administration to facilitate Abrego Garcia's release from prison in El Salvador, and that was affirmed and reinforced by the Supreme Court. So, get this, under the heading of false premise objections, defendants, the Trump administration, through the arguments being presented by his DOJ lawyers, defendants object to certain discovery because they claim the requests are based on the, quote, false premise that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador. Defendants, the Trump administration, and their counsel, the DOJ lawyers, well know that the falsehood lies not in any supposed premise, but in the DOJ's continued mischaracterization of the Supreme Court's order. That order made clear that this court properly required the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Defendants, Trump and his DOJ lawyers, Objection reflects a willful and bad faith refusal to comply with discovery obligations. So, friends, before we tick through some of the other findings by the judge that are extraordinarily damning of the Trump administration and his DOJ lawyers, I want to pause here for just a minute to take on the implications, the consequences of a federal judge making those findings about how DOJ lawyers are behaving. They're offering things like, quote, falsehoods to the court. They're acting in, quote, willful bad faith in refusing to comply with court orders. So, what are the consequences when a judge finds that DOJ lawyers engaged in this kind of misconduct, this kind of unethical behavior? Generally speaking, there are a few consequences attorneys will suffer once a judge makes those kinds of findings. But the first really depends on the leadership of the Department of Justice. If the Department of Justice was led by people who cared about the ethics, the integrity, the candor, the honesty of the lawyers they sent into court to argue these cases, well, then the lawyer could be sanctioned by the Department of Justice, frankly, could lose their position, maybe even lose their job with the federal government. I mean, these findings are devastating to the career of a Department of Justice lawyer in normal times, when DOJ leadership cares about the rule of law and the oath that all attorneys take to the Constitution, not to the president. So another consequence is these lawyers will almost certainly be referred to their state bar. What does that mean? So if you're a lawyer with the Department of Justice, such that you're going into federal court and handling cases, here's how things typically work. After you graduate law school, you take a state bar exam in, your state of residence. Most typically, once you pass the bar and you join the federal government, the Department of Justice, and become a practicing DOJ lawyer, you can practice in all federal courts around the country. You just have to be barred in one state. You have to have a law license issued by one state. However, if there are allegations of misconduct, of, ethical violations, particularly if a judge has found that you engaged in misconduct, DOJ lawyers will almost certainly and invariably be referred to their own state bar counsel for an investigation and for possible sanctions up to and including disbarment. So these lawyers are, in a very real sense, putting their bar licenses on the line by making these false arguments and by acting in willful bad faith. And then there is a third potential consequence. Inside the Department of Justice, there's something called the Office of Professional Responsibility, OPR. That's an office that is empowered to investigate, among other things, allegations of attorney misconduct. But do you really think Pam Bondi's DOJ, right, the Department of Justice as led by Attorney General Pam Bondi and her henchmen like Todd Blanche and Emile Bove, do you really think they're going to refer their own attorneys to their internal ethical watchdog, the Office of Professional Responsibility, to be held accountable for these unethical acts that they are undertaking in furtherance of the Trump administration? Friends, you've heard me say before, I'm not a betting man. I am not a high roller. $1 is my betting limit. I wouldn't put one nickel of that $1 maximum bet on DOJ policing the ethics of their own in Trump-related cases. Let's go back to some of the other findings in Judge Xinis' new order. Here's just a flavor of some of the judge's other findings. DOJ's boilerplate, non-particularized objections are presumptively invalid and reflect a willful refusal to comply with this court's discovery order and governing rules. although defendants state now that they are willing to meet and confer with counsel about the production of such a log, their repeated refusals to meet and confer about much of anything else undermine the reliability of this assertion. The court thus finds this offer was not made in good faith. Defendants, the Trump administration, and DOJ have known, at least since last week, that this court requires specific legal and factual showings to support any claim of privilege. Yet, they have continued to rely on boilerplate assertions. That ends now. If defendants want to preserve their privilege claims, they must support them with the required detail. Otherwise, they will lose those protections they failed to properly invoke. Defendants, Trump and the DOJ, object to any discovery requests concerning events predating the court's April 4, 2025 order as beyond the scope of the expedited discovery. Defendants' arbitrarily cramped reading of the court's order is rejected. Defendants' answer to interrogatory number 5 reflects a deliberate evasion of their fundamental discovery obligations. Given the context of this case, defendants, the Trump administration, and the DOJ lawyers have failed to respond in good faith, and their refusal to do so can only be viewed as willful and intentional non-compliance. And on and on and on it goes. You know, friends, at this point, here's what I want to say about these DOJ lawyers who are offering falsehoods and who are acting in bad faith. This reflects DOJ lawyering at its worst. You know, in fact, you really can't even call it lawyering. It's a failure, a refusal to act as a lawyer. It's a flagrant, intentional, and obstinate disregard for the authority of the court. And it's a slap in the face to the American people whose interests the DOJ lawyers are sworn to represent. Put another way, it's like sending a Trump PR flack into court to thumb their nose at the judge, to mock the rule of law, and to undermine our Constitution. Now, these people are not acting like DOJ lawyers. They're acting like the dictator's little helpers. And I have to believe that they ultimately will be held accountable for the damage they're doing, not just to Abrego Garcia, but to all the American people. Accountability. Because justice matters.